Good evening. Welcome to 42 Barristers. This is our fourth and final season in our current family law series and the last for 2025. My name is Anne Osborne. I'm one of the family law barristers here at 42, and I'm joined with my lovely colleague Alison Pryor. Alison, would you like to say a little bit about yourself?
Yes, thank you. I'm also on the family team, practicing mostly in care, but a little bit of private law as well. And looking forward to presenting this seminar this evening.
Now, the topic of this evening is leaving care provisions demystified. I know that we had a little postponement and we apologise for that, but we hope that you'll find this evening very informative. All the previous recordings can be found on our website. For any questions that arise as a consequence of this webinar, please go to the Q&A box. You will be able, time permitting, to have those questions answered. If we run out of time, then please send your questions to events@42br.com and we will revert to you as soon as possible. An email containing the recording and any feedback form will be circulated over the next few days. Equally, if you'd like to have a copy of the slides, then no doubt that can be provided to you then. So just to give you a little flavour of what this webinar will cover, we are going to look at the statutory provisions providing to the leaving care provisions. Then we will look at which young people these provisions touch on. We will have a look at the statutory definitions for the categories of young people. There are a number of categories. And then the framework for pathway planning, concluding with pathway planning do's and don'ts. And at the footer, we will give you some useful resource material that you can delve into for a bit more in-depth material. So Alison is going to kick us off with the relevant statutory provisions. So we'll have a look at that on the next slide. Over to you, Alison.
Thank you. So as you can see here, there are a number of statutes that we're going to look at, all of which deal with duties that local authorities have towards children leaving care. If we go to the next slide, we can look at the Children Act 1989 as amended by the Children Leaving Care Acts. And you can see there, there's a list of the relevant provisions, quite a lot of them. I'm not going to go through all of them, but I'm just going to pick out the ones that are really probably the most relevant and which are going to be addressed a little bit further later on. As you'll see in a moment when Anne presents the next section, care leave are divided into four broad categories, depending on the particular arrangements that were in place. And the Children Act contains provisions which are relevant to all four of the groups, and Anne's going to talk about that a little bit more in a moment. The key sections of the Children Act are sections 23A and 23B, and that sets out the duties towards relevant children. And that relevant children is defined in the care leavers regulations, which we're going to look at in a moment. Also, section 23C is key. That talks about duties towards former relevant children. That's the second category. And then we move on to section 23E. And Schedule 2, paragraph 19A of Schedule 2, that looks at pathway plans, which we're going to deal with towards the end of this evening's seminar, as Anne's just explained. And then section 24 talks about the duties towards persons in the group known as persons qualifying for advice and assistance. So those are really the key parts of the Children Act. And as I said, we'll look at that in a bit more detail in a moment. The next piece of legislation is on the next slide. That's the care planning, placement and case review, England regulations, which I'm sure most of us are familiar with, perhaps for other topics, not just this one. Here, part 7 is the relevant section. And it's a really important set of regulations because it sets out the requirements for pathway plans and also the functions of a personal advisor. Both are really critical to making sure that care leavers are set on the right path as they leave care. The next provision on the next slide is the Care Leavers England regulations. And this contains some definitions, relevant children, for example, as I mentioned earlier. It sets out what local authorities need to do when they're assessing need and setting up pathway plans for relevant children and former relevant children, and also sets out the functions of personal advisors. And then part four of these regulations deals with a number of things, including other sources of support to be provided for relevant children. So another important part of the statutory scheme. On the next slide, we come to the Children and Young Persons Act of 2008. The key parts here are Section 21, which, as you can see, deals with financial duties on local authorities where children are going on to pursue higher education, and Section 22, which again deals with source of support for education and training. And then Sections 20 and 28 I thought was worth highlighting because it's not perhaps very well known, but in fact, there's a requirement on schools to have a member of staff designated specifically for pupils who are or who have been looked after, which can be really important for them. On the next slide, we've got the Children and Families Act 2014. Again, this deals with duties to pay relevant amounts to do with higher education and duty towards looked after children at schools. And then finally, we've got the Children and Social Work Act 2017, excuse me, which we set out on the next slide. So sections 2 and 3 of this act set out services that are to be provided to care leavers, and then sections 4 to 7 deal with duties of local authorities and schools. With the aim there is to promote the educational achievement of previously looked after children and looked after children. This is quite an important piece of legislation because it outlines in law for the first time, really, what it means for a local authority to be a good corporate parent. And it sets out the principles there, which are or include acting in the best interests and promoting the physical and mental health and well-being of children in care and care leavers. And that involves or includes encouraging them to express their views and to take those into account, to promote high aspirations and seeking to secure the best outcomes, and for children in care and care leavers to be safe and have stability in their home lives, their relationships and education and work, and of course, really importantly, to prepare care leavers for adulthood and independent living. And the Act reminds councillors and officers of local authorities that they are all corporate parents, whether that's county council or district council, and that every councillor is responsible for making sure that their council meets the duties set out in the statutory scheme towards children in care and care leavers. And that means that when any service is being reviewed that could impact on care leavers, the councillors have to ask themselves, what if this were my child? What can I do to do any problem that's been to put any problem that's been identified right? And finally, this Act requires local authorities to publish what's called a local offer for care leavers, which is all services offered by the council that can support care leavers in adulthood and independent living, or for preparing for this. So that includes both services that the local authority is statutorily obliged to provide, things such as we've just looked at in the statutes I've just run through, but also discretionary support and services provided by other organisations. And in publishing the local offer, it's mandatory that care leavers are consulted before it's published. So that's a very, very quick gallop through the statutory scheme. I'm going to hand back over to Anne now, who's going to talk about relevant and former relevant children.
Thank you, Alison. So as you will have picked up from Alison's comprehensive account on the statute, there are different categories of young people that these provisions apply to. There are 4 key groups of young people: the looked after children, eligible children, qualifying young people, and former relevant young people. So I'm going to deal with relevant children. And on the slide headed relevant children, you'll see that section 23B1 of the 1989 Children Act requires local authorities that last looked after the child to take reasonable steps to stay in contact with that child. I suppose a question could be, well, what are the reasonable steps? And I suppose that one of the things that they would need to do is to ensure that they've got contact number for the child. They know where the child is supposed to be settled, and require the child essentially to keep them appraised if they move. Later on in the slides, there is a requirement for local authorities to ensure that they carry out visits if that child moves, and we'll touch on that later on. But those are the reasonable steps that I would say on a practical level local authorities should be taking. Then regulations 4 and 5 of the care leavers regulations very useful in terms of setting out the requirement for an assessment of the relevant child's needs with a view to determining what advice, assistance, and support they're going to require. That would need to be set out in a pathway plan, and so those inquiries are quite crucial in planning for the child as they prepare to leave care. One of the key things to remember is that although we often think of planning for a child when they hit about 16 or approaching 16, that is something that should be kept under review and actually in the forefront of minds even before the child arrives at that age. What are they going to need? How do we care plan towards that? Then Regulation 6 sets out the requirements for preparing the pathway plan, and that is further repeated in the 1989 Act, sections 23B, 3B, and I'll leave you to have a read of that. They're quite informative in terms of the detail of what they expect local authorities to do. You'll see that Regulation 7 of the Care Leavers regulations also has a requirement for the pathway plan to be kept under regular review. So we move on to the next slide that I'd like to take you to, and that is going to be in relation to former relevant children. And I did skip ahead of myself because I didn't tell you what those children are. There are some definitions that I've set out for you within the slides, and when you receive them, you'll find that particularly in slides 15 and 16, we've set out what the definitions are of eligible children and relevant children, and the relevant statute that tells us what those definitions are and which young people are caught by those regulations. But what I'm going to do is I'm going to move on a little bit onto the former relevant children, and we're going to have a little look at what we are required to do. So Section 23C, 2 of the Children Act, that provides the duty of the local authorities, and it also sets out the requirement of appointing a personal advisor for the former relevant child, in addition to keeping that pathway plan under review and to provide any assistance to that former relevant child. And assistance to the extent that the child identifies that need. So, where we have young people who are over the age of 18 but under the age of 25, they can require the local authority to provide them with assistance, and they can set out what sort of assistance they need. It might be in terms of ongoing education, it might be by way of grants, it might also be by way of training. And those are the things that local authorities do have a duty to provide if that young person requests that. So those requirements are quite comprehensive and they're fairly wide ranging. The young person is key to those requirements. It's very much informed and led by their needs, but also identifying with them what those needs are and involving them in that process to inform what sort of plans are made around their identification of their housing needs, their educational needs, and in some instances, any immigration needs that they may have, because we will have some young people who may have arrived with families before they were taken into care or whilst they were being taken into care because they might have arrived as unaccompanied minors. And so those sorts of inquiries will need to form part and parcel of the planning that we have as we go forward with those young people. So I'm now going to pass you back to Alison because she is going to talk to you about the next group of young people, which would be the relevant child, which would be the eligible child and qualifying young person.
Thank you, Anne. So I'm going to, if we can just have slide 12 very briefly, that contains the definition of eligible children. As set out in Schedule 2 to 1989 Act, and then also in the care planning regulations, which I mentioned earlier. So as you can see, it's a young person who's 16 or 17, who's been either in care for at least one day, age 16 or 17, or looked after for at least 13 weeks from the age of 14. And there's some further sort of qualifications about how that time spent in care can be made up, which you can see there below. So sorry to jump around, but if we can have slide 16, that would be really helpful, because that sets out a bit more detail about what the duties are towards eligible children. I suppose the key here is that the duties are forward looking, because eligible children are, of course, 16, 17. They're not yet care leavers. So the idea is that the local authority should be doing some forward planning for these children, so that everything that should be put in place when they come to leave care is in place. And that includes, crucially, once again, pathway plans and personal advisors. So what the care planning regulations require the local authority to do with this group of children is to prepare an assessment of their needs, so that they can determine what advice, assistance, support it would be appropriate for the local authority to provide, both while the eligible child is still looked after, but also crucially after they stop being looked after. Also, there's the requirement to, as soon as possible after the assessment as needs has been completed, the local authority has to prepare the pathway plan that you've heard us talk about a lot, and we're going to address in detail in a moment. That pathway plan also includes the child's care plan. And Regulation 43 of the care planning regulations stipulates what has to go into the pathway plan. So it's and there are very specific requirements. And there's also the requirement that pathway plan has to be kept under regular review. And then, as I mentioned, it's the other duty on the local authority towards these children is to make sure that a personal advisor is appointed for them. That's somebody to work with them, a source of advice and support, and someone to whom or who can help with the implementation of the pathway plan. I'm not sure if I'm going to go on to qualifying children now. Shall I deal with that, Anne, or do you want to deal with your next group?
If you'd like to do that, Alison.
Okay, thank you. So the next group of care leavers is what are called qualifying children, or qualifying care leavers sometimes. The definition is on slide 13. I'll just run through that quickly. We don't need to skip back to that. These are young people who are aged between 16 and 25. They're people who were looked after by children's services either on or after their 16th birthday, but they're no longer looked after. Also, they need to have spent less than 13 weeks in care since their 14th birthday, and they don't meet the criteria for a full criteria for relevant or eligible children. These the duties towards qualifying children are mainly contained in section 24A, including it can sometimes be unclear as to which local authority has the duty to provide services to these children. So that sets out the regime which will decide who's in charge of providing the support. In addition, in the case of it sets out in the case of a young person who's formerly looked after by a local authority, the local authority who last looked after that young person has to take the steps that they consider appropriate. And again, as Anne's already said, that's, I suppose, open to interpretation, but to keep in touch with them so they can make sure that they discharge their functions under section 24A and 24B of the Children Act. So that's qualifying children.
So Alison's taken you through qualifying children. I think we've already touched on former relevant young children, have we? Yes. And so the next thing that we'd like to take you on to is the framework for accommodation and support, I think. Is that right, Alison?
Yes, I think so.
Yes. So we now have up slide number 21. And the National Care Leavers Association and Accommodation and Support Framework sets out 5 steps that local authorities have to bear in mind when they are thinking of devising positive accommodation pathways for care leavers. And I've set out in some bullet points what those are. So it's about training young people on tenancies in the housing market, because that's going to be crucial for them, involving young people in the arrangements around their accommodation, uh, also having emergency options for young people, and then commissioning a wide range of housing types for young people who will be from a quite broad range of ages. Developing skills and confidence ahead of a move into independent living. And that's going to be quite crucial for young people managing finances, budgeting, thinking ahead about how they arrange their accommodation and what might be required of them when they move into their own accommodation. That then dovetails with the pathway planning, which is on slide 22. And as I alluded to earlier, the pathway planning really does need to start well before the child hits their 16th birthday. It must be in place for all children who are looked after age 16 to 17, who have been looked after for at least 13 weeks after they reached the age of 14. And the point of that is really about having some foresight about what is to come for those young people, not waiting until the last moment to start that planning, because there's so much that needs to go into that planning. That planning and transitioning to adulthood must take place for every looked after child, unless there's any other status that the young person may have. And it needs to be reviewed every 6 months. Although it needs to be reviewed every 6 months, that doesn't mean that that's the only point at which it can be reviewed. If the young person or someone else concerned with their welfare requires a review of that planning, that should be facilitated, because there may be very good reasons why they're asking for review. So, in essence, that pathway plan remains a live document. It's not something that's just signed off and forgotten about. It continues to evolve with the child's needs and with their own identified wishes around education or housing. The care plan that travels with the child needs to feed into that pathway plan. So, whatever's within that care plan also needs to be reflected in the pathway plan. If the child is subject to a personal education plan, PEP, that also needs to be fed into the pathway planning. And then if we have a look at slide 23, the views of the young person, as I mentioned, do need to be reflected in that pathway plan. The pathway plan must set out how their views were elicited and what they've set out their views to be. If there are any other interested persons who have fed into that pathway plan, that needs to be properly recorded within that pathway plan. So it is a very comprehensive document that really properly records what's been said by whom and what flows from that, what services should flow from that, and how those services are going to be provided for. The local authority must monitor that former relevant child's pathway plan and provide a personal advisor to continue doing that with them. And if that young person is either of the age of 21 or is not in educational training, or reaches the age of 21 or over and has finished educational training, or reaches the age of 25, and they then request assistance until that age of 25, the local authority has that ongoing duty to continue updating that pathway plan and to provide that personal advisor who's going to support that young person on that journey. Alison, did you want to pick up for the next bullet points onwards?
Yes, absolutely. So as the slide makes clear, the personal advisor appointed for the young person has to be in regular face-to-face contact with every care leaver they're supporting. and the pathway plan has to set out the expectations of the personal advisor to see the care leaver, and if required, what arrangements there are for staying in touch in other ways. Also, if a care leaver moves to new accommodation, then the personal advisor has to see them there within 7 days of the move. And then thereafter, they have to see them at the point at which the pathway plan will be first reviewed. So that's 28 days, and then no less than 2 monthly intervals. And it's important to bear in mind that those are just the minimum requirements, just to satisfy the statutory duty. Often it will be necessary for more frequent visits to take place, but that's just the minimum. The next slide, slide 23, goes on to set out the other requirements of pathway plans. So that is that the care leaver has to be provided with a copy of the plan. And it's really important that the plan contains concrete targets, such as who's responsible for the conduct and coordination of the assessment of the young persons for the pathway plan to be produced, what the timetable is for that assessment, who's to be consulted, how outcomes are to be recorded, and how representations are going to be made if there's a disagreement about what should go into the pathway plan. Onto the next slide, it says that it's important the plan details any concerns about the young person's health, support required to reach any career goals the young person has, and crucially how the local authority will support the young person. And that includes financial support, but also support with accommodation and support with identity documents, really the crucial elements to helping that young person achieve independence that as a corporate parent fall upon the local authority to cover. The plan also has to cover accommodation, life skills, education, training, employment, any specific support needs the young person has, and financial support. And then finally, also really importantly, if there are any additional needs in the individual young person arising from their having been, for example, human trafficked, or being an unaccompanied asylum seeker, then that needs to be addressed within the pathway plan as well. So that's pathway plans. There are also quite a lot of ways in which local authorities are expected to provide financial support for care leavers, which I just thought it might help to run through just at the end here. You've heard about, or we've dealt with some duties of financial support, but there are others that perhaps aren't so well known about. So, for example, in Section 24B of the Children Act, there are duties for the local authority to assist with expenses to do with education training. That can include the cost of work clothes and so on. Again, coming back to that principle of being a corporate parent and ensuring that the young person has what they need to strike out in life on their own, have the best chances. It can cover support for digital devices, exam fees, books and activities, and anything else they might need. And in fact, to the extent the young person's welfare requires it, it can cover other assistance which can be made in kind or even exceptionally in cash. And that support, they're entitled to that support until they turn 21 or until the programme of education ends. And then for care leavers who attend university, there's a duty to provide former relevant children, to provide care leavers with a bursary of at least £2,000 over the duration of their course. That's set out in some regulations which we didn't cover at the beginning because it's quite niche, but it's the Children Act 1989 Higher Education Bursary Regulations. And that's it also imposes a duty on local authorities to provide vacation support during the summer holidays. That's also covered in Section 24 of the Children Act. And then it's worth remembering as well that care experienced students are often entitled to additional bursaries, scholarships and grants, which universities and charities put forward. And there's also the bursary fund scheme for 16 to 19-year-olds, which care leavers aged 16 to 19 are entitled to apply for. And then finally, care leavers who start an apprenticeship are also entitled to a £3,000 bursary, which is paid in instalments over the first year of the apprenticeship, and that's under the Apprenticeships Care Leavers Bursary Guidance. Some of those sources of financial support aren't provided by the local authority, but as I said, I thought it was just worth running through, because actually when you start to look at what is out there for care leavers, there's quite a lot of different sources of financial support for those going on to education and training, which is well worth being aware of. I think that we've come to the end of the slides, but we've got time for questions if anybody has any. Anne, are you able to deal with that? Sorry, I can't see
Yes, I can. I can't see any questions yet, but I'm sure that if anyone has any questions, then they will put them in the chat, which I can see. Don't see any questions arising yet, but if anyone has any questions after the event, or having seen the slides, there are questions that emerge, please do email them in. I will read out the email address so that you can send those through again. It's events@42br.com, and I'll pop that in the chat as well, so that you can have that email address to raise any questions. There we are.
I ought to have mentioned, just while I was dealing with the financial support, there's an additional resource which is a really helpful guide to what local authorities have to do, and the guiding principles, which we'll add to the slides if anyone wants to have a look after the talk. I think we've been so comprehensive that nobody has any questions.
Yes, I think we blinded them with it. Okay.
Well, the recording
Please do feel free to get in touch with us, either directly or through our events channel. And if you have missed some bits of it, you can watch it again on our YouTube channel.
Thank you very much, and keep an eye out for our 2026 series of webinars, which will be coming out within the next week or so.